Hi, welcome back, Attorney Steve Vondran. We are talking in this video about declaratory judgment in BitTorrent cases. Okay, so everybody knows now, if you've been watching my channel, our firm is a leader in the area of handling Malibu Media cases, Strike 3 holdings, two of the biggest, most prolific filers of torrent file sharing lawsuits, downloading and sharing their videos through the torrent clients. So here's a case that just came out of Illinois. Okay, this is the Northern District, or wait, no, rather, this is the Northern District of Illinois Eastern Division. So it's a little confusing, but this is from Illinois, and this involves a plaintiff, Malibu Media, that filed their torrent file sharing lawsuit. And what happened is they ended up naming the defendant Najia Khan as the defendant in the lawsuit. A lot of times these cases proceed as does, but as you can see, this one, can you see that? They named him personally here, and he said, I didn't do it, you got the wrong guy. They named him anyway, okay? At any rate, without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, here we are. So I want to talk about this because we've talked about this in other cases and blogs and whatnot. As a defendant in these file sharing cases, you need to think about this, discuss with your attorney. Does it make sense to file a counterclaim for declaratory judgment? Declaratory judgment telling the court to declare that I am not an infringer. A declaratory judgment seeking a determination of non-infringement of a copyright, okay? So there is precedent. This is persuasive authority that you can cite in a case. And, you know, it's just crazy because what happens is these plaintiffs bring these complaints, okay? Here's their complaint. And what happens is if a defendant goes through their discovery and they go, yeah, you know, geez, we got the wrong guy. It's not Khan after all. And so, but Khan's already named on the complaint here. So that, what in other words, that besmirches the person's name, and they don't have a chance to clear their name. The plaintiff may dismiss the case, and defendant goes, okay, well, can I get attorney fees? Can I get something? I mean, this is like crazy. Can I clear my name? Can I get an apology letter? Anything? No, plaintiff dismissed, sorry. So the reason they're filing these declaratory judgment actions is to get a declaration of non-infringement, to clear their good name, and to provide themselves a basis for getting attorney fees, okay? Because usually in a copyright action, it's the prevailing party who's going to get their attorney fees. If you've been dismissed, many courts would say, well, you were dismissed. It's not like you prevailed. They just decided not to go forward for whatever reason. So the declaratory judgment counterclaim gives you a chance to say, I want a declaration that I'm not an infringer, clear my good name. Then if they dismiss, I've got my counterclaim pending here, and I want to seek my attorney fees on this, okay? So this is the whole purpose here. Now, in this case, this Malibu Media case, here's the case citation, if you need it, 118-CV-03028. Again, Illinois Northern District. The defendant said, the plaintiff, Malibu Media, said, wait. You can't just file this declaration of non-infringement. That's an affirmative defense. You just say, I didn't infringe anybody's copyright. I didn't infringe. And they filed a motion to dismiss saying, Judge, this is just redundant. It's the same thing. It's just the same as their answer. There's nothing here. And they tried to argue this would cause additional burden on them to have to respond to this. Okay, the court disagreed. The judge denied, in part, the relevant part that we're talking about, denied their motion to dismiss this non-infringement declaratory judgment counterclaim. I know there's a lot of jargon there, but just realize that there are some courts that will allow this counterclaim, this declaratory judgment counterclaim, to survive and proceed through. Maybe it turns out the guy did it. Who knows? Okay, so maybe not. So at any rate, that gives them maybe a better basis for settlement or whatever's going to happen here. But it keeps their claim in action. Okay, so this was a court. I'm just going to read you a couple things here. This is from the courts, Judge Harry Leinenweber. He says this case is one of a deluge of cases brought over the years by plaintiff Malibu Media. Let's see what else we have here. Hang on. Sorry about the delay there. I know you're busy. But the court talked about Malibu Media saying this is redundant. The court said it is important to note that the court has broad discretion in considering and granting declaratory judgment. So the judge has broad discretion on this. Khan's counterclaim is redundant in that it repackages her denial of copyright infringements. Nevertheless, under this, she seeks more than just declaratory relief. Section 505 of Title 17 of the United States Code provides that attorney's fees may be awarded to a prevailing party in a copyright infringement case, but when the plaintiff voluntarily dismisses its copyright claim without prejudice under Federal Rules of Civil Procedure 41A, the defendant is not considered a prevailing party. So that's what we're saying. So you can, as a defendant who's prevailing on this, they're dismissing their claim, they're cutting and running, as other courts have called it. And the court goes on to say, to reiterate, Malibu Media can voluntarily dismiss the action before the court reaches a final judgment in allowing the counterclaim to proceed. So they're denying the motion, allowing the counterclaim to proceed. The court reaches a final judgment in allowing the counterclaim to proceed. However, Khan can still pursue a final judgment. It bears mentioning that damages for copyright infringement in this case and others is significant. Moreover, the potentially embarrassing nature of the alleged copyright violation can provide grounds for abuse. There is tremendous pressure for a defendant to settle, even if the case is meritless. That's absolutely true. Khan's counterclaim will offer protection should she choose to challenge Malibu Media's case on the merits instead of submitting to the settlement. As she points out, it also affords an opportunity for her to clear her name. Accordingly, Malibu Media argument fails. Malibu Media nevertheless contends it will be unduly prejudiced by having to litigate duplicative issues. The court disagrees. Malibu Media will be required to answer Khan's counterclaim, but that imposes a negligible burden. So you get what we're saying here. In torrent cases, in copyright infringement cases, photo infringement, software infringement, video infringement, all these different things, jewelry infringement's another one, font infringement, all kinds of things. You need to be thinking, talk to your attorney about, do we file a counterclaim? I'm not saying they're always going to be granted. Sometimes they are denied. It's at the broad discretion of the judge. But this needs to be pointed out. If you're going to do it, point out that you just don't want the plaintiff to be able to cut and run, dismiss you after they've already smeared your good name, and you don't have the ability to get attorney fees. So there it is, folks. There you have some case law. You have some decisions coming from federal courts. And if you need help in a torrent defense case, you know where to find us. AttorneySteve.com. That's AttorneySteve.com. The first name in legal services, or as we like to say, you click, we defend. You click, we defend. Okay? Have a great day. I hope you've enjoyed this. We'll be back on Monday. I've got some friends coming in from out of town, so I'm going to be out this weekend. But have a great week. Make sure you subscribe if you like our channel. If you have any comments, leave some nice comments. I've been getting some people are, I don't know, frustrated or angry with their lives or something. But leave nice, productive comments. I'm trying to have a nice channel here, okay? Thanks a lot. Have a great week. We'll see you again. Bye now.